Welcome back to the Deep Dive. We're here to really get into the weeds of complex topics, pull out those key insights, and make them make sense for you. Today, we're jumping into a really interesting slice of Florida law, a case from back in '87, Bevan v. Wanicka. Now, on the surface, it might look like just another public records fight, but trust me, it's got layers. It reveals some absolutely fundamental stuff about open government that's, well, just as relevant now as it was then. We're looking specifically at the decision from the Second District Court of Appeal. This is an ancient history. It's a classic case showing how a simple request for information can blow up into a major legal battle. And it ended up clarifying really clearly what public agencies can and importantly cannot ask of people seeking records. So our mission today, to really unpack this court opinion, pull out those fine points, those critical lessons, especially for those of you who already know your way around open government law. This case distinguishes the everyday request from, full-blown litigation.
Yeah, and what's really fascinating about Bevan v. Wanicka is how it just keeps popping up. It's decades old, sure, but the principles it lays out still incredibly relevant, especially, I think, for lawyers, journalists, advocates, anyone really working with public records day to day. It just perfectly captures that tension, doesn't it, between the public's right to see records, which is broad, and the government's need to, well, defend itself when someone accuses them of serious stuff like hiding or destroying those records. It's a real balancing act, and Bevan gives us a surprisingly clear roadmap for navigating it.
Okay, so let's set the stage. How did this whole thing start? The person bringing the suit was Brian Bevan. He sued Wanicka and others, saying they violated Florida's Public Records Act. His initial goal was pretty specific, right?
Yeah.
He wanted police records about an investigation into someone's death, a William B. Jackman. That seems like a standard request under the law back then, Section 119.07.
Exactly. Textbook request.
But then things took a sharp turn. And this is where it gets really interesting for the legal side of things. Bevan didn't just ask for the records they had. He actually amended his complaint. He added a really serious charge that the police department or someone there had destroyed or concealed the very records he was after.
And that changes everything.
Totally. It wasn't just, give me the files anymore. It was, you got rid of the files. An accusation of, well, misconduct. That shift from just wanting access to alleging wrongdoing turned it from a simple records demand into proper litigation, needing fact-finding, potentially challenging what the government did. And, like you'd expect in litigation, this new serious claim made the other side, Wanicka and the others, want discovery from Bevan. So what exactly did they ask him for?
Right. And their discovery demands really zeroed in on the conflict. They wanted three specific things from Bevan, seemingly to test his new allegations. First, any dirt on him, his past criminal history. Second, names, numbers, addresses of any witnesses who told him about these supposedly missing records. And third, similar details for any private investigators he might have hired to track down these missing records. You can see the focus shift, right, away from just providing records towards probing Bevan's accusation itself.
And how did the trial court handle that?
Well, that's where the first real fight happened. The trial court actually gave Bevan some protection, a protective order for some other things the Atellis wanted. But it ordered him to hand over those three key pieces: his criminal history, info on witnesses to the missing records, and info on PIs looking for those records. That ruling basically lit the fuse for Bevan v. Wanicka. Bevan obviously wasn't happy. He went straight to the Second District Court of Appeal, asking for what's called a writ of certiorari. He argued the trial court's order was way off base, a departure from the essential requirements of the law, and would cause irreparable harm if he had to reveal that info right away.
That's like an emergency appeal, right? Trying to stop something before it happens?
Exactly. You use certiorari for non-final orders that seem clearly wrong and damaging, but, the DCA denied his petition. Just denied it. No explanation. That must have felt like a major blow at the time.
Yeah, a denial without opinion can be tough. So after that denial, what happened back in the trial court? The trial court basically doubled down, issued a slightly modified order, but still told Bevan he had to answer questions about his criminal history. And maybe more importantly, about witnesses who had personal knowledge regarding whether those records actually existed or not. So still directly targeting his concealment claim.
Right. Directly tied to whether his accusation held water.
But Bevan, he just wouldn't budge. He refused, point blank, refused to answer this specific questions. Even when the judge gave him another chance during a contempt hearing, Bevan said no again. That's risky.
Definitely a high-stakes move.
And the result? The trial court didn't hold him in contempt, which is usually what you'd expect. Instead, it dropped the hammer, dismissed his entire lawsuit with prejudice.
Ouch. That's the ultimate penalty in civil cases.
For sure. It meant his case was over, no chance to argue the merits. And that dismissal is what he appealed, leading to the main Bevan v. Wanicka opinion we're digging into.
Okay, and this brings up a really key procedural point. On appeal, the appellees Wanicka and Company argued that the DCA's earlier denial of certiorari was now the law of the case, meaning they claimed the issue was already decided and couldn't be revisited.
Ah, so they were saying you already had your chance to fight this discovery order and you lost.
Pretty much. But how did the second DCA handle that argument?
This is crucial, isn't it?
Absolutely crucial for anyone doing appeals in Florida. The court flatly rejected it. They cited another case, Don Mott Agency, and made it crystal clear. A simple denial of certiorari without opinion is not an affirmance and does not establish the law of the case. That's a huge takeaway. Just because the higher court didn't take up the case early on through certiorari doesn't mean they agreed with the lower court. It just means they didn't exercise their discretion to hear it then. The legal issues were still wide open for review once there was a final judgment, the dismissal in this case. That procedural ruling was vital for Bevan. It kept his appeal alive.
Okay, so that procedural block is cleared. Now the court can actually get into the substance, the heart of the matter. Florida's Public Records Act. Let's just restate the core principle, the bedrock idea. All state, county, local government records in Florida, they're open for anyone to see, full stop.
Yeah.
Unless there's a specific law, a statute, that carves out an exemption. The court pointed to the Tribune Co. case for this.
Right. That's the default. Openness.
And here's the kicker, the part that directly hits the discovery dispute. The Act doesn't make your right to see records dependent on who you are or your background. Section 119.087 says that explicitly. So think about it. Why is that specific point that your background, like a criminal history, is off limits so critical when they were demanding Bevan's criminal past?
Well, connected to the whole point of open government, right? It's fundamental. The court's saying Section 119.07 doesn't care about your background. That stops agencies from trying to block access based on who's asking or why they're asking. It's about the records being public, not about the person asking. It prevents intimidation. And the court even hammered this home by referencing News Press Publishing Company v. Gadd. That case basically said the Public Records Act does not direct itself to the motivation of the person who seeks the records. Your reasons, your past, generally irrelevant to your right to access.
Okay, so background and motivation are out for simple access requests.
Right. But then the Bevan court made a really sharp distinction. This is key. They said Bevan's lawsuit became more than a request for public records. Why? Because he didn't just ask for records. He alleged destruction and concealment. That specific, serious accusation, it changed the game for discovery. Because of that claim, the court said, yes, the appellees were entitled to discover the source of those specific allegations. Basically, if you claim records were destroyed, they can ask, okay, how do you know that?
Makes sense. You make a serious charge, they can ask for your proof.
Exactly. But, and this is the crucial balancing act, the court immediately drew a line. It found no relevant reason to force Bevan to reveal his past criminal record. That ties right back to News Press. Your criminal record might speak to your character, maybe motivation, but that's not relevant to whether records were destroyed or even to your right to ask about them in the first place. So discovery is allowed for the destruction claim, but it has to be about the claim itself, not about Bevan as a person. They could ask, who told you, but not, were you ever arrested? Big difference.
Okay, so breaking it down, the second DCA reversed the dismissal. Big win for Bevan, right? He gets another chance.
Huge win for him in the appeal, absolutely.
But the court didn't just say, okay, start over. They gave really specific instructions for what happens next on remand back to the trial court.
Yeah, very precise. They sent it back for an evidentiary hearing, the main goal. Figure out if the appellees had actually given Bevan all the public records he was entitled to, get the access part sorted first, and then came the conditionality, the really careful part. If, and only if, Bevan still pushed his claim about destruction and concealment at that hearing, only then could the trial court revisit the discovery about his knowledge, who told him, how he knew.
Wow. It's surgically precise. Deal with records access first. If the destruction claim persists after that, then allow tailored discovery on that specific claim.
Exactly. It reinforces the right to access, but also provides a practical way to handle those serious litigation-specific accusations without letting discovery run wild. Protects the plaintiff from fishing expeditions, protects the defendant's right to defend against specific charges.
So for people working with open government law day in and day out, what are the big takeaways here?
I think there are two main things. First, Bevan is a powerful reminder that the right to inspect public records in Florida is broad. It's unconditional. Your identity, your motive, shouldn't matter. Agencies can't use discovery to dig into your personal life just because you asked for records. That protects everyone seeking information. But second, Bevan gives us that crucial framework for when discovery is okay. If you go beyond just asking for records, if you start suing and alleging things like destruction or concealment, then yes, the agency can ask questions. And it's a big, but that discovery has to be laser focused on your specific allegations, not a general background check. It's about the facts of the alleged wrongdoing. The court struck a really smart balance, didn't it? Protecting access, but allowing focused discovery for serious claims.
It really did. So, recapping our dive. Bevan v. Wanicka is a cornerstone case. It protects that unconditional right to see public records, stopping agencies from asking irrelevant personal questions just because you showed up asking for documents. Essential for transparency, but it also draws that really vital line. When a case escalates, when you allege records were hidden or destroyed, discovery rules shift. But they shift in a very controlled way, focused only on the allegation, not the person making it.
Right. It's about the substance of the concealment claim, not the character of the requester.
It definitely gets to the truth of the alleged wrongdoing without chilling that fundamental right to access in the first place.
Which leads to a final thought, maybe something for you to chew on. How does this balance, struck way back in 1987, hold up today? We're in a world where records are increasingly digital, sometimes fleeting think texts, instant messages, stuff that can vanish easily. How does the Bevan framework apply when proving concealment might involve digital forensics, metadata, things unimaginable back then? It raises this ongoing question. How do we ensure full transparency and allow for necessary discovery when the very nature of records and concealment is constantly evolving with technology? That's the challenge, I think, for applying these principles now.